All right. Good morning, everyone. I see that we've got like a few people in here already. Hi, my name is Lee, and I'm going to be your host for today's webinar. We've got Helena also here with us. You all should be seeing us over here to the side of the screen, and you should also be seeing a slide that says Workers' Compensation Wednesdays, July 2026. So we are going to be recording the session today, so your portion of the call is muted. So to be able to ask questions during the presentation, what you're going to want to do is pull up the chat pod. The way that you do that is up at the top, you should see a row of buttons. One of them says chat and has a little talk bubble on it. Click on that, and that's going to pull up the chat pod to the right of your screen. So if you want to test that out, you can certainly feel free to do that. Just remember that whatever you put in the chat, everyone can see it. So just keep that in mind. If you've got questions or comments of a confidential nature, you're going to want to maybe save those for connecting with one of us directly. So good morning, Tara. So good morning, everybody. Um, it is going to be fairly quiet. You'll hear us kind of talking back and forth, but letting us know if you can hear us okay would be great. I assume that you can hear me because I can see you typing good morning. And I'm going to have Helena say something as well, so we can check her microphone as well.
Good morning, everybody. Glad y'all are attending this morning.
Perfect. So we are going to be getting started at 10, which means we've got about 5 more minutes. So we're going to sit and kind of wait for folks to hop on the call, and then we'll be getting started right around 10. Um, and like I said, it will probably be a little bit quiet until then. But go ahead and put questions in the chat pod if you've got them, and we'll be getting started here in just a few minutes. Good morning, everybody. We've got quite a few more people who've joined us since I last popped on. So I just wanted to make sure that all of you know that you are in the right place if you're here for our Workers' Compensation Wednesday for July 2026. We are going to be getting started here right at 10 a.m., which is in about a minute. If you have not already done so, you are going to want to put your chat pod up to the right of your screen. The way that you do that is look up. You should see a row of buttons. One of them looks like a chat bubble and it says chat underneath. If you click on that, it will pull up the chat to the right of your screen and you'll be able to ask questions during our presentation. Just a note on the chat, everyone can see what you're typing in there. So if you've got questions or comments that are confidential, you might want to save those. So we're going to be getting started here in just a couple of minutes. It'll take a minute or two for everybody who's trying to log in. So as soon as we get most everybody settled, we're going to be getting started. My clock just turned 10 to 10, so I'm going to go ahead and get started on my little spiel. But my name is Lee Bell Hovland, and I'm your host for today's webinar. I've probably been talking to quite a few of you in the over the last couple of weeks just because of the safety equipment program. It's been very busy. I am not your speaker today. Your speaker today is Ms. Helena Barmore, who is our Workers' Compensation Program Supervisor. So we expect to be here for about an hour today, more or less depending on how many questions you all may have during the presentation. And again, you're going to want to use your chat pod to be able to ask questions during our presentation. So the way that you do that is to move your cursor up to the top, click on that chat bubble. All right, so without further ado, we're going to get started. Helena, you can take it away, and I'm going to take myself off screen.
All right. Good morning, everybody. My name is Helena Barmore. I am your Workers' Compensation Claims Program Supervisor for the Texas Association of Counties. I work in the Risk Management Services Department. And if I haven't had an opportunity to visit with you, please take the opportunity to reach out to me. And if you haven't had a one-on-one training on workers' compensation for counties, be sure and let me know. Anybody that on your staff that might be involved in the work comp program. It's about a 90-minute program, one-on-one, where we talk about just the nuts and bolts of workers' compensation and how you handle things on a daily basis. And I'll be happy to do that. So that's my little spiel on that. So this month, for July 2026, our Workers' Compensation Wednesday, we will get started. We do this each month around mid-month so that we can talk about current workers' compensation benefits. So as I move forward with this, so each month I have to remind you that we have a disclaimer that we're not providing any legal advice on behalf of TAC. However, I am a professional licensed workers' compensation adjuster. I'm fingerprinted with the state and I'm held accountable for criminal acts by the state as well. So if you ever have any questions, you can feel fairly confident that the information that I'm providing you is certainly something that we can go to the Division of Workers' Compensation and be able to rely upon. Workers' compensation, of course, is a regulated coverage. In fact, it's the only regulated coverage with the coverages provided by the risk pools and for the Texas Association of Counties. And we are regulated through the Texas Department of Insurance. So there's relief with Texas Department of Insurance, but all of our guidance and all of our administrative code compliance is done through the Division of Workers' Compensation, which is a sub-department of the Texas Department of Insurance. But if you have any legal issues, we will generally drive you either, particularly if it's personnel related, to a HR consultant through TAC, which you have access through with your contributions to our program. Or we may direct you back to your county attorney, or you seek a competent attorney of your own choosing in order to be able to answer certain questions. So why do we do this? We do this because we have a lot of things in workers' compensation that has layer upon layer upon layer that works that interacts with each other and that can have downstream consequences to your program, to the cost of your program, with the outcomes of your claims, and then also in order to ensure that we've got good outcomes for all of your employees who are injured in the line of duty or in their workplace. Complications that affect workers' compensation can include pre-existing conditions, things that have to be investigated, mechanism of injury, and we certainly want to have a very broad understanding of how workers' compensation works, so that in your role with your particular entity, public county or public subdivision entity, that you'll be able to provide the best resources to your employees so they get the best experience from the workers' compensation claim. So our objectives, the objectives that we're looking at each time when we do these things, we're going to be talking about coverage, compensability, compensation, typically everything we do to manage and administer a claim. We're going to be focusing on first responders because about 65% of our claims are actually come from EMS, firefighting, and from our law enforcement personnel. We also talk about things like loss runs, or how we coding, what kind of forms do we have to do. That's the administrative, probably the most boring part of the workers' compensation piece, is filling out the paperwork. We do believe that we need to partner and make sure that we've got that information correct, so that we're not only making sure the profile for our employees' claims are being set up properly, but we are transmitting the proper data that we are required under law to send to the Texas Department of Insurance, which is representing the state of Texas, and for the Center of Medicare and Medicaid Services, which we have a requirement to send as well for the federal government. We also want to provide resources, training opportunities. I feel that those are really important. And then share some information from the Division of Workers' Compensation. You are a stakeholder with the Division of Workers' Compensation, and so I want to encourage you to be aware of what's going on there as well, and any training opportunities. Okay, so our agenda today, we are going to talk about coverage, which is something we're going to touch on each time. We're going to talk about the unholy trinity story behind that, which will also include how reputational risk. We have so much risk when we talk about programs. And I know that in May, when we started this journey together, we talked a little bit about the risk associated in the workplace, which is the obvious things: falling over a box, slipping on a wet surface. But risk can expand to other things, such as reputational risk. And we're talking about how important that is in our environment, particularly as we approach the legislative season. We're going to again talk about first responder claims. We started on the presumption. How does the presumption work in a workers' compensation environment? We're going to move to part 2 of that today. We'll briefly cover more part 1 again to just kind of connect everything together. Today we're going to talk a little bit more about cardiovascular events. The next thing that was on our agenda is we're going to talk about the first report of injury, and how important that the information on the first report of injury is eventually put to the point where it affects how our loss runs are developed. Those loss runs are very important because that's what underwriting uses in order to be able to establish severity, frequency, and eventually which impacts your contributions and the bottom line cost of your program. And then finally, we're going to talk about some DWIC updates. There's some new training opportunities available to you. All right, so we're going to start right out of the chute. We're going to go back in history. We're going to talk about the Industrial Revolution and employers' liability. I want to say back in the old days, this is way old. This is over 100 years ago, when the Industrial Revolution, something that you may remember back in your past, schooling years, is that we had some really gray factories. We had people who were working, and they were working shift work, and they were working hard works, and they worked for very low wages, and they had some probably not very good working conditions compared to what we're accustomed to today. But there was some underlying legal issues that made it even more difficult than just the fact that, you know, you're going to work and you work in a grueling shift and then you're out the door and then you're home and you're not pocketing a lot of money in your pocket, because workers' compensation did not exist back then. And to show the impact and how important workers' compensation is in our workplace, let's look to see what would happen if someone was injured in that work environment back in the Industrial Revolution. And I'm going to put you back into the late 19th century and the early 20th century, when you were seeing the expansion of manufacturing facilities. You see that commerce was moving to the northeastern part of the country, moving from an agricultural environment into the factories, into the manufacturing plants that were literally being centered in the Midwest and the western in the northeast part of the United States. So we had three rules that were in place when we looked at defending someone who was injured at work. We had contributory negligence, fellow servant rule, and the assumption of risk. This allows an employee to actually file a claim against their employer directly or file a lawsuit. So to defend that lawsuit, if someone was injured, they would use one of these defenses. The employer would use a defense to show that they were not the employee had no entitlement for any type of compensation, unless there was a rule that was put in place by that company that if someone was injured, they would get something. So the most common is that the employee is at fault. If they picked up a box that was too heavy, or they dropped a wrench and it landed on their foot, or a piece of equipment was toppled over, they accidentally toppled a piece of equipment over and it landed on them. If they were at fault, they were legally entitled to nothing. The only thing that they would receive from their employer was that the employer graciously set out to them for them, whether it was for a short amount of pay, or even a lump sum, or to pay for some of the medical bills to a doctor of their choice, the employer's choice rather. That would be all they would get, and there was really very little compensation back for them. If they went to a court of law, that was a valid defense. The second one is the fellow servant rules, that the coworker was at fault. So if you were working side by side in a manufacturing thing, and if the employer perceived that a coworker may have accidentally injured because they're working in an assembly thing and they're passing equipment or something, and someone bumped against each other, or that there was an accident caused by that coworker, then that would be a defense. The employer wouldn't be at fault. It would be the coworker that was at fault. And then the employee could actually sue their coworker for compensation if they were injured on the job. The third one is called the assumption of risk, and this is the price to pay to work. And the description I generally use is, if you had a chance to ever see it was a show, and it just completely escaped me. It's called Gunsmoke. There was a character in it called Marshall Dillon, and he was a U.S. Marshal. In those roles, if they were out there and they were being, chasing the bad guys and shooting guns at each other, if they were actually injured or killed, there was no compensation except what may have been set aside by the U.S. government, because they assumed the risk of their jobs. That if you were killed and you assumed the risk of that job, then there was very little compensation for their family because of the assumption of risk. And that traveled all the way down through the manufacturing environment, where that if you were working in a skyscraper, and you were working 72 stories above the ground, if you went out on a scaffolding area, or you were out doing welding work out on the anywhere, you might actually be assuming that risk of taking of going out there and having that incredible height out there. And if you fell, that was your fault. So you could see where this sounds pretty extraordinary to us in our world today, but back then that was considered the unholy trinity, and those were the defenses that an employer had against their employees to protect them from lawsuits. Sounds pretty extraordinary, but it was in place. So if we go to the next slide, maybe you'll remember, if those of you who might have been with us back in May, we talked about risks such as hazards as physical, morale, and moral hazards. Think of this in terms of what it looked like back in the late 19th and 19th century and the early 20th century on how workers' compensation might have been viewed. Because if you're not doing risk management, if you're not doing safety, if there's nothing to compel you to do that, you're obviously going to have those physicals, morale, and moral issues. So we're going to talk a little bit about probably one of the most extraordinary events that changed workers' compensation in the United States and eventually all over the world. On March the 25th, 1911, we had the Triangle Shirtwaist Factory fire. This occurred, and this is in Manhattan, New York. Where this happened was right in an area that behind this building was a very affluent neighborhood of people from the political life, from social life, what we would consider terming celebrities now, very grand homes, people whose names were in the gossip columns and in the what would be the social media networking back in the day when would be like the daily newspaper. I think human beings have a unique capacity to be trying to seek out social networking, and they want to know what's going on the next street. So they had their own little internet aspect of it, so everybody knew would know what was happening. So this was very visible because of where it was located in Manhattan. So this fire that occurred into the Triangle Shirtwaist Factory occurred on the 8th through 10th floor of this ash building. It was a privately owned company. They had approximately 500 workers. Most of them were immigrant women. They earned very little bit amount, less than $12 a week, and they worked 52 hours a week. So notably, this happened on a Saturday. 148 people died from smoke inhalation or fell to their death. The doors and the exits were locked. Why do you think they were locked? They didn't want anybody slipping out to smoke or to take a break. They wanted them to work. Their job was to work. They all had quotas to fulfill. And so they actually locked the doors during work period. The cartoon back then, a lot of social political commentary were done through cartoons that were placed into printed publications such as newspapers. And so you will see that you have a what is considered to look a very malevolent photograph of an employer holding the door against people on the other side. And that was what really was advertised for anyone that would be reading those things, and it did form public opinion. So this is what the inside of that shirtwaist factory looked like. You'll see all of these women, and there were men there too. I mean, it wasn't just limited to women. They were required to dress certain ways. They were required to sit in these roles. They were all kind of, it looks like a very, well-organized factory, but the reality is these doors were locked, and this is actually one of the floors on which the fire occurred. And then you will see what showed up in this is an example of what was in the Boston Globe, not even the New York paper. So even though we have social media now, we can see things almost instantaneously in the internet. Even over 100 years ago, they had a way to get the message out, and so this did really kind of caught across the United States about what happened, because if we have visions of what happened on 9/11, we had visions of women who were literally on fire jumping out of that building at the time. And so that was an extraordinary spectacle which was relayed across the United States and the world. And then this is the photographs. there was probably less censorship in photograph and newspapers back then. So these photographs are fairly readily, you can locate them on the internet, but you can see how devastating to see bodies. And I know these are pretty graphic, so I apologize for that. But this is pretty graphic example of what was being seen in the newspapers. So if you're thinking about reputational risk, you can imagine what it did to the owners of this factory, but also the reality of really how people, what the working conditions are, and what happened. But what came next was even more extraordinary. And I'm going to go back to this screen right here. They filed suit. Employees got together, families got together, and they filed suit against the things. Lots of things came out of this. They identified that there was no sprinkler systems, and sprinkler systems existed back there. They were able to pump water. There was no water on those floors. The waters hadn't been working on those floors. There was no access for water on those floors. What actually started is someone threw something in a trash can, and the trash can caught on fire, and then everything ignited from there. That was what the final the final fire report was on it. So you had about a $60,000 property loss for the damage to that building. Remember, this is over 100 years ago, so I know that seems a little bit low in our current terms. But what was remarkable is after 148 people died, plus people suffering from smoke inhalation, only $16,000 was distributed under personal injury claims. $16,000 because somebody caused that fire in that trash can, and they didn't look at any very little mitigation towards the damages. This actually went to trial. Well, when I saw the results of this, and of course we already have heightened awareness about what was going on following this incident, it caused tremendous editorial pushback in the newspapers. It was an outcry politically that went to state houses all the way across the nation. It was viewed in the United States Capitol regarding issues for how workplace injuries happened. It was so extraordinary that it caught people's imagination, and they actually started moving. In fact, there was actually a protest in New York where very similar to what you would with people's outcry, with a parade and everything to bring this to everyone's attention. So it was a tremendous horrible impact to the people who owned the building and who owned the business. Their reputational risk was a fact, but it really affected the reputational risk of really anybody across the board in the manufacturing industry. So now it creates a timeline, because once politically something catches fire, so to speak, things start moving. Now, there was already some things that were starting. There was the federal government was already looking at putting in workers' compensation. So 3 years before this happened, the FELA, which is the Federal Employees Liability Act, which is actually continuing in place now for things like, railroad workers and things like that, for anybody who's federally covered under federal workers' compensation, that had been installed. But nothing was done at the state level, because the states control their own insurance programs. So nothing really started hitting until 1911, the year of this fire, and the first state act changed in Wisconsin. Texas was one of the few that came afterwards in 1913. We actually had a state act in Texas, and we had the creation of the Industrial Accident Board in 1917. That Industrial Accident Board stayed in place into 1991, by the way, and remained a pretty solid workers' compensation program through that period of time. In 1974, under the Industrial Accident Board, the Texas Association of Counties formed the self-insurance fund, and that was when the state decided to have a mandate that public entities were required to have workers' compensation coverage, and that was actually what caused the risk pool to be in place to have affordable options for counties and for public entities to have workers' compensation. In 1989, of course, we had a change to the new Texas Workers' Compensation Act, and that formed the Texas Workers' Compensation. In 2004, that's when we actually had started utilizing the third-party administrator that ended up being Sedgwick. And then in 2005, the workers' compensation changed again with the Sunset, with the Sunset Act, and formed the Division of Workers' Compensation, what we have now. So as you continue that timeline, we are where we are today with our program, and it all started with an event which was as extraordinary as this Triangle Shirtwaist fire that occurred in New York. So we can see from this perspective, when we look and examine how reputational risk is, how important it is in the life of workers' compensation, because of all of your coverages, even discounting the law enforcement liability, your most politically charged coverage, insurance or not, is going to be your workers' compensation coverage, because there's always this emotional attachment to employees, making sure that employees are taken care of in their environment at work, to make certain that they are that we're addressing those earlier risks that we commented about: physical risk, morale risk, and moral risk. Because if you attach those three risks and think is in context to what happened with the Triangle Shirtwaist factory fire, you can illustrate very clearly how those risks fit into that storyline, and how that reputational risk rolls all the way into what we have today. And that same scenario on a much smaller scale can affect each one of our all of our political subdivisions that are members of our workers' compensation pool, when we are looking at how do we handle our safety, how do we handle our administrating of our workers' compensation program, how do we handle simply taking care of our employees in that environment, so that we don't suffer the consequence of reputational risk. This is an extraordinary example of that, but one of the best examples that I see to see how it affected workers' compensation all the way across the board historically, but also how it can affect us individually because of where we are today. So I hope that story had of some interest to you, and it had some relevance to the timeline of where we are in our workers' compensation journey together. It all connects. Everything that we talk about connects to each other. And in that respect, I felt that it was very relevant to our discussion. So now that I got through all the gloomy stuff this morning, I'm going to turn to first responder claims. Last month we talked about communicable disease exposures, including the addition in September of 2025 through the legislative action of identifying death investigators and how they were affected. So let me change the screen here. That's the screen I wanted to go to. I'm working off of two screens, and I do apologize because I can barely see the one that's up on the team screen, so I have to use a secondary screen. So just to give you an example of why my face might be changing. Okay, so first responders for presumption. Last month we talked a little bit about communicable disease exposures and how they were impacted, because those were actually the first evidence of presumption in workers' compensation to take care of things like tuberculosis and smallpox. We don't see smallpox very often anywhere in the news anymore, but we are seeing a rise of tuberculosis in the state of Texas, and so those are new claims that are kind of coming up the pike. So we want to be very aware that those could be presumption. Those need to be reported to us as quickly as possible. Again, Texas has a rebuttable presumption, which means we investigate them and make a determination whether they meet the presumption or not. If we do find that there's some evidence to show that they're outside of the presumption and we can actually need to decline the claim, we can still do that. There are some states that have removed the rebuttable presumption to make it a full presumption. If Texas ever gets to that, we would see a rise in cost across the board, because a non-rebuttable presumption means that if an employee files the claim, we don't have the right to deny it. So unless they're just not an eligible employee. So that's something that we watch, because it goes back to reputational risk. If there's any perception by our legislature that we're not properly handling claims, or we're showing any bias to our first responder employees, then obviously their next step might be taking that choice away from us when we handle those claims. So presumption is that we remove the burden of proof from the employee having to prove up that they have a compensable injury to the employer or the risk pool, in your case, because we represent you in that particular scenario, that we would be able to define that their compensable injury is not related to the work environment, but we would have the burden of proof to do that. It just shifts that burden of proof. So when we're looking at presumption, we are looking at the government code, and under the chapter 607, there is a very specific chapter that's related to these diseases that we're taking a look at. So just to recap from what we talked about last month in June, we're looking at diseases that are not ordinary diseases of life. We're looking at exposures which are within the course and scope of employment or in line of duty for first responders. We're looking for, situation that might occur during the investigation of a death investigation, where an employee might be like a medical examiner or a justice of the peace, or maybe an investigator from, sometimes even the DA's office, would be exposed to human remains which might actually have a disease that might provide them communicable disease. We did learn during COVID that exposure to someone who had COVID who had passed did provide adequate exposure to someone to get COVID. So I think that's probably where a lot of this is actually generating from, is what happened during the COVID years, and they're putting in place for finally something to protect the death professionals, the death investigative professionals. Also, the presumption would apply to those illnesses that would require vaccinations, like smallpox, tuberculosis, things like that. I'll throw in there rabies. I think that if that's a little bit on the side, but if you've got people working animal shelters or in those environments, if they have an exposure to rabies, and then they going to have to require those shots, the prophylactic shots, they may require those vaccinations in the future in their work environment, working with those animals. They would be covered as well under the workers' compensation program. And then in those situations where we might have exposure to family members for tuberculosis and things like that, if vaccines are available for those type of diseases, and there is a concern about exposing family members, we might find that the county may have exposure to pay for vaccinations for families. I haven't seen that really fall out on the workers' compensation side, but it may be something that may pop up and have a requirement for the counties in the future. So it's been there for a long while. I just haven't seen it invoked, but just be aware that that's out there. Finally, I'm just going to kind of reach down the smallpox, tuberculosis, respiratory illnesses, and COVID. That's now being excluded, but smallpox and tuberculosis are probably the ones that we need to be keeping an eye on, because we're seeing some emerging diseases in Texas that we haven't seen for decades, and we certainly want to be prepared. So today what we're going to talk a little bit about the application of I'm going to change my screen here on my private screen too, so that I'm on the same stuff here. Bear with me just a moment. Okay, so when we talk about presumption under 607.052, which is driving the presumption more towards the cardiovascular, the cancer, which is actually affecting the firefighters, but cardiovascular strokes, that affects EMS, firefighters, and mostly law enforcement. We see most of our heart attacks, strokes are really involving law enforcement employees. And so there's some applications for presumption, and I've highlighted a few things on this particular slide. So if if someone is onboarded as an employee with the county and they receive a pre-employment physical, and that physical fails to show any evidence of an illness or a disease at the time of that pre-employment physical, then that opens the way for them to have a presumption at a later date. If they had a pre-employment physical that showed that they had something like cancer or maybe cardiovascular disease or anything like that, and that was identified to be a pre-existing condition, that removes them from the presumption. So how that information is recorded by as an employer, if you have a fit for duty program for your law enforcement or for your first responders, that would be where would you record that information? That information may need to be made available to us when we're actually investigating a presumption. That employee also needs to be employed for 5 years as in that role. And so that's the type of information that we can probably easily get from personnel. It's going to be more difficult, though, for someone who is a volunteer firefighter. We would have to work with the volunteer fire department to see how long they've been joined as a volunteer for that entity. But that 5 years is important because it establishes some level of a common denominator with the employer to show that if anything happened over that 5 years, that would be a reasonable period of time for something to develop. Also, we would be looking at, let me just see this a little bit thing, get my glasses off here. If they're seeking benefits, they have to be limited to the diseases and the illnesses which are actually included in that chapter, which goes with those items that we talked about last month: smallpox, tuberculosis, some respiratory diseases, and then, of course, something very specific to the cardiovascular and cancer. We're going to talk about cancer next month. On the next screen, which is very, very busy. Again, if you want a copy of this presentation, we just have to get information over to, I believe, Lee, and we can get a copy of it, or you can send me an email and I can send you a copy of the presentation. This is actually part of the government code that can be pulled up online. I did highlight in red, a couple of things in this. There's some things under presumption where it doesn't apply. And so if you have an employee who smokes, say you have a employee who smokes, or it's identified that their spouse or partner smokes, then they're removed from the presumption. Tobacco use, and it's not even considered smoking, it's tobacco use, which can also include anything that they might do, like with snuff or anything like that. That would remove them from the presumption, because of course that's going to raise the risk of having cancer or a cardiovascular event if they are smoking. And it doesn't matter if they quit 20 years ago, if they ever smoked, it will take them out of the presumption. Very specific for volunteer firefighters on how you can identify that because of the cancer presumption, because obviously with firefighters there's going to be so much there's always a concern about being exposed to carcinogenic chemicals and smoke, anything like that which might impact for cancer. So there's some very specific things there. And then the subchapter which applies, everything is very, very specific within this government code to the definition of who is a peace officer, who's not a peace officer. Everything has to occur during the scope of employment or be defined by another statute. So specific to myocardial infarction or stroke events, which again, we see more with law enforcement. We just recently had a situation with a firefighter due to a heat exhaust. Probably, we've had a lot of fires right now, and in these events can also be a downstream consequence of heat exhaustion. So that's always our biggest concern with firefighters is heat exhaustion, because a combination with the fire that they're actually fighting riding, and then with the incredible heats that we've had and the addition of humidity, it's just a terrible scenario for someone to putting that kind of stress on their bodies. So, but there are some very specific things. They have to be engaged in a situation that involves stressful or strenuous physical activity. Um, they've extended that to other things as well, but it can't be they can't include clerical, administrative, or things that would be considered essentially I think the term that they're utilizing for this, I'm sorry, I didn't change your screen there. The non-manual activities. I mean, they're trying to set the stage that if you are involved in a stressful activity or doing something that would bring up your heart rate, things like that, then that would actually bring it into presumption so that the burden of proof would shift from the employee to the employer. We do see that from each legislative session, we see an expansion of where inclusion for this presumption is. It makes it much easier for a first responder to get a favorable ruling on their workers' compensation claims. And of course, these are very generous benefits associated with these claims. You know, you accept a heart attack, you accept a stroke case, you end up usually taking care of someone for the rest of their life. Cancer cases as well. So a couple of things that's changed over the past few years, in addition to just being in a stressful situation, expanding how far that can go, is the fact that heart attack doesn't necessarily have to happen at work. It can actually happen at home. It has to happen within 8 hours after the end of the shift. Those are investigated very carefully. We've had claims filed over the several years where someone has gone home overnight, they have a heart attack and they passed away overnight, and we've had to look at those. But generally, if we find that there's a significant evidence of pre-existing condition, cardiovascular disease, things they might have been treating over a long period of time or things like that, that might actually remove it from the workers' compensation environment, but we still have to handle it under the presumption, which it's very difficult to do that. We have a lot of protocols that we have to follow through. We have deadlines that we have to hit. We have to be very transparent in our investigation. When we have a case under presumption, we'll be asking for a lot of information from the employer, from coworkers, from doing investigations. Many times we will engage an outside investigator. The reason we do that is not to be invasive and to be pushy, but we have deadlines that we have to attend to. We have a 15-day pay or deny criteria, which means we have to file paperwork with the state advising exactly what we're going to do 1, 2, 3, 4, 5, 6, 7, 8 in order to be able to investigate our claim. Sometimes it's difficult because the circumstances of the claims, sometimes they shift and we may not have all the information we need in that first 2 weeks, particularly in a death claim. And then we have 60 days to make a decision once we have all that information in our control. So your participation and help with us during that period of time is greatly appreciated. I see the only question so far is about getting the slides for a download, and I see that Lee has responded to that. If you have any other questions, be sure and let me know. I'm not monitoring the chat very carefully right now. So we're going to change to the next topic, which of course is talking about a first report of injury. The reason I wanted to visit with you about the first report of injury is that this impacts how well this is completed, impacts how the information for the profile for your employee is set up. Now, generally we get everything we need. This is not something I'm too terribly concerned about, but this form, if you just look at the form itself, the form is really kind of hard to fill out, even though it's in a fillable PDF, and most of you are actually using online portal to report claims to Sedgwick at this time. But having information such as, you know, the correct email address, phone number, things like that is really important, because most of the communication with your employees now is through email, texting, you know, very little the conversations we're having on phones right now seems like they have reduced quite a bit. Now, we do average about 5,000 phone calls a month for the claims team. And they're on the phone quite a bit. They truly are. I know sometimes they're difficult to get a hold of, and we're just continuing to work with Sedgwick in order to make sure that that's improving. But a lot of your employees really just don't want to talk to their adjusters. They would rather text, they would rather email. And so we need to make sure that we've got all methods of communication. We know what their preferred methods might be. Another thing that has appeared over the last, that's been, irrelevant from some of the surveys I think we've received and from talking to some of our members is that employees are presuming that when they call and they leave their number because their number's showing up on, they think that someone's just going to call the number back. They're not leaving voicemail messages. So that's kind of a phenomenon that's coming to our attention more and more, is that an employee will say, well, I called and no one answered, but they're calling and they're not leaving a voicemail, or not leaving a concise voicemail that includes, I need for you to call me back at this specific date and time, or maybe this is a phone number, things like that. They're making assumptions that, the phone number is being recorded, that, maybe the name is being recorded with the phone number. And unfortunately, these commercial phone systems, that's not necessarily the case. So we do want as much information as we can so that we can reach these people and have as much information as far as the claim goes in the description of accident, things like that. But some of the things that we do have missing is on field number 16, first day absent from work. We need to make sure we've got dates in those places where we absolutely can properly, identify timeframes, because those timeframes attach to compliance issues with the state of Texas, and those dates are all going over. So if whether you're putting it into the portal with that information, don't ever skip those fields. We have to have that information in order for it to go over to the state. On the second page, which is the next screen, you're going to see things like the number of days absent from work, the actual return to date, date of hire. We just frequently lose that information, or we don't see it. That information, the rate of pay, all that information really needs to be filled, because those are all required, and that's required fields that need to go over to the state. So if you put it in through the portal, most likely you might be prompted that information may be insufficient if it's not completed. However, if you're putting it on a first report of injury, if you're just doing the fillable PDF or you're handwriting it and you fail to get that information, we might be able to force it through, or we could estimate something in order to get the claim filed with the state. But if you can get that information on it, that's great. What I will tell everyone, though, is that if you need to get a claim filed and you don't have all the information you need, I would strongly recommend that you go ahead and you file it, and then the adjuster will call and say that they need additional information. They can fill it in. But if the information is available to you, please fill it out. The last thing I want to point out is regarding the loss runs, is that if you look under part 3, and this is the second page that I have up on the screen right now, if you look under part 3, employment information, under occupation of injured employee, this is probably the field that is left off the most. In order for us to be able to properly code your claim so that you have proper contribution alignment at time of reconciliation, we need to know what that employer's job was. So if they were working in an administrative role and they were working the treasurer's office, or if they're working in the county clerk's office, or they were working in just county operations, or they're working in a precinct, we need to know which department they're attached to, or who the elected official is that they roll up to, in order for us to put them in the proper department, and also determine what their occupational code should be. So if you have someone who is a deputy clerk in the sheriff's office, we need to know that they are administrative employees so they can be properly coded. If they are a deputy in the sheriff's office, we need to understand that they truly are a deputy sheriff and they would be coded as law enforcement personnel. So attention to that will actually help clean up our loss runs. We'll actually get them in the right departments, and then we can actually make certain that our underwriting is using the proper information when they're establishing contributions. Now, generally, there's very few coding changes, but when you identify that something is not properly set on a loss run, you're visiting with one of your consultants and you notice that something is wrong, either somebody's appearing on your report that shouldn't be there, because again, business name needs to be the name of the county or the political subdivision, but occasionally we'll see some manual entries where even on our side with the third-party administrator, they'll see something that starts with with a certain letter and they'll accidentally put the wrong county's name in there. So we want to make sure that things are correct, but we do recognize that mistakes happen. So we certainly appreciate you helping us out to make sure that those are corrected. Next slide. This also emphasizes that on any form that you utilize that is a DWIC form, DWC form, that you can find on the Texas Department of Insurance website, there's always going to be a frequently asked question page in which you be able to get answers to some more high level questions. So final thoughts on the DWIC 1 is that we want to make certain that file those claims notice, upon receipt of notice as soon as you can. The state says that they need to be sent to the carrier for your purposes as the pool, and the employee within 8 days. After the employee's been away from work 1 day, or you've received notice of an occupational disease, or if the employee dies. So you have 8 days to get these things out under those circumstances. So if someone has a medical only claim and they didn't lose any time from work, the state's kind of silent on how long it takes to get those filed. But the reality is, if you don't get the claim set up, we can't get the reserve set up to pay the bills. So, even on medical only claims, you want to get those to us as quickly as possible. The DWIC 1 itself is a record that the employer must maintain a record of. Now, these can be digitally maintained, and we have them in all the claim files. So if you ever had a request for records, we could always pull that up for you. But most of you guys maintain records, I think, with your personnel records. But you must maintain the record of the DWIC 1 for 5 years from the last day of the end of the year where the injury occurred. So, my recommendation is you just say, okay, we're going to keep these for at least 6 years. Those must be on record, because if the commissioner says we would like to review your records, you have to present it to them within 5 days of notice, and it has to be at a reasonable time and place. I do not anticipate the state coming in and reviewing your records. In fact, I've never had that situation occur in my 46 years of handling claims and being involved in public entity scenarios. But again, it's written in the administrative code, so just be aware that it's there, because failure to maintain that record could result in administrative penalty not to exceed $500, but that would be $500 per incident, not just an overall $500. Not to say that they would just automatically assess a fine like that, but just be aware of what the consequences might be. Loss runs. So each you guys should be receiving a loss run. Quarterly loss runs are sent. So for example, we just finished up quarter 2 on June the 30th. So loss runs should have gone out July 1st, and they go to the pool coordinator or a designated recipient. So we have a lot of workers' compensation pool coordinators that have been receiving them over a long period of time. We need to make certain that everybody's receiving those loss runs. If you don't rely on your quarterly loss runs and you just need to have a report created, you can do it upon request by contacting me. I'll ask you what you want on that report, and I'll create that report for you so that you can use it for whatever reason you want. We've got some members who ask it very specific to certain departments, like the sheriff's sheriff's office, or they'll want to look at just the road and bridge department. But I can provide reports in order for you to be able to, something that you can utilize internally. I do know that the consultants who frequently visit our members brings copies of the loss runs that are generated through risk management services, not only with your workers' compensation program, but with the other coverage lines that you can visit with your consultants, and it comes basically from the same data bank. Loss runs that I review, however, come from actually Sedgwick system, so I get them in real time. So if you need something immediately, you may want to come to me instead of your consultant to get the real-time report. And I just briefly showed you on the bottom of this screen what a loss run, this kind of little snapshot of what that loss run might entail. But generally we'll put like the description of loss. I didn't want to include that here because it might, reveal a little bit too much information on one of the claims. But we can carry a lot of information. The Sedgwick fields, there's 300 fields in the Sedgwick system that we can generate and put into a loss run. So that can be helpful if you're doing some internal worker planning. So finally, I want to talk a little bit about updates, moving to what's going on at the Division of Workers' Compensation in the last few minutes. So we have just finished our performance-based oversight, which ended on June the 30th. I want to thank each and every one of you that were working with us, making sure that our DWIC 3s, our wage statements were in place, working with us on establishing post-injury earnings, particularly with our first responders who have salary continuation. All of these things help us to have a measure of success. I'm feeling pretty confident that we will return back to high tier this year. I do believe that Sedgwick's worked very, very hard to try to reach that, and I do know that we've had a lot of our members who have had to kind of change the way they do things in order for us to meet the needs that the division has for post-injury earnings now. That will continue. That's not going to stop, but I think as we get that protocol in place, and we'll return to have more discussions about how we do calculate temporary income benefits, which is impacted by salary continuation as a post-injury earning. It makes our program better. It makes sure our employees are being compensated more fairly and they're getting the benefits in which they're entitled. We'll be getting the results in August. I don't expect them any earlier than that. We have to, in order for us to reach high tier, we have to have 95% compliance rate. That seems high, but we have high expectations with the Texas Department of Insurance. We just received, I've reported this to you before, we had a audit that's going on with the Texas Department of Insurance for lifetime income benefit and death benefit audit. We just received the response to that. I'm going to be very transparent. I'm a little disappointed with the response, with the outcome of that report. Like I said, the Texas Department of Insurance is raising the bar. This report goes back 8 years. And so there's some things that we can do better for your employees. And I think that we'll be putting that information in place. Most of it had to do with calculation of benefits. And another component to that was that for those cases where we had a salary continuation on lifetime income benefits for an employee who had a catastrophic injury but was off work and we're still receiving salary continuation, maybe having to come back to some of y'all to get some confirmation of what benefits were actually paid under salary continuation in order to be able to mitigate some of the comments that were made, because we did not capture the salary continuation information probably adequately, and we're going to have to roll that into the rebuttal. So just be prepared for me contacting you on that kind of information for those of you who have employees who unfortunately had a catastrophic event and are receiving lifetime income benefits. So those are those additional requests I'm commenting about right now. Also, just going to the next screen, one more thing about the DeWitt conference. The registrations are still open for that. I know that the discounted rate passed on June the 30th. So if anyone has this in their budget and they can attend that, or even consider budgeting for it in the future, I want you to consider that, because it's a really pretty good conference. And then we've got something that anybody can attend. This is actually a free Zoom meeting presentation by the Texas Department of Insurance under comp courses. This is Workers' Compensation 101. It is going to happen on August the 5th. It is a 1-hour presentation. I believe everything I've really seen with DWIC lately has been very, very good with their training. I would encourage each and every one of you who have time during that period to actually try to sign on, and this will give you good taste for the kind of trainings that they have. This is an online training. For any of you that might be needing CE hours, if you have an adjuster's license that are involving risk management, this would actually give you some credit. I will actually be attending it as well because I'm constantly looking for training opportunities and to renew things that, every day I think I lose more than I gain every day in that brain of mine. So I would encourage you to consider attending that as well. So really, we're at the end of our discussion today. I want to thank everybody for attending. Does anybody have any questions they want to share at this time?
While we're waiting to see if anybody's typing in any questions, I just want to let everybody know that we will be back here for our next Workers' Compensation Wednesday on August the 19th. Same time, same place. If you have not already registered for that, it is on our calendar of events on our county.org website. We will also be sending out a reminder email about that and registration a couple weeks before, so probably around the beginning of August. So it doesn't look like we've got any questions coming over, Helena. If you want to wrap this up completely, we can move along in our day. Give everybody 2 minutes back.
Well, I'm hoping that there's no questions because my information was concise and informative. However, if you have any questions, you know that you're always welcome to give me a call or to contact me at your convenience. I think my information is right there on the screen, and I do enjoy working with each and every one of you. For those of you who don't ever have any claims, good work, but please reach out to me if anything pops up, and then I can offer you any assistance. So as we're approaching the 11 o'clock hour, I want y'all to have a wonderful day today, and I look forward to anybody who shows up at our party next month.
Helena, we did have a question about Grace Salinas is asking, is the meeting next month going to be the same or cover something different?
The meeting will be, every meeting will cover something different. Now, there will be components there where we may have some overlap, and the point of doing that is to ensure that, just like any type of educational environment, is that we may have a little bit of recap on something as we move into a new nuance. So like next month, I definitely have set aside talking about cancer and presumption. We've got more and more counties that are interacting more with firefighters, and we are seeing a phenomenon where we've got a lot of firefighters that are coming from dense population areas that are signing on either with volunteer fire departments, or they're actually joining county fire departments that are bringing all of their past history with them. The last employer holds the bag. So those are things that we're going to be talking about. Probably going to talk a little bit more about start moving towards compensability and some of the things the county can do to be aware of compensability issues as we're moving forward. This program is designed to give everyone a broader, deeper visit on workers' compensation. So naturally, you're going to have a little bit of overlap each presentation, but each presentation will be different, distinctly different.
All right. Well, that was pretty much it that we got in terms of questions. So thanks everyone for joining us today, and hopefully we'll see you again next month. Have a good one.
Thank you again. Bye-bye.